The premise of EUDR is to prevent timber and other products linked to deforestation from entering the EU. And while the UK is not the target of those regulations, EUDR is a whole supply chain issue. It follows timber from the forest while it's processed and onto the retailer. If we don't engage with EUDR, we risk creating two product streams in the UK: timber with EUDR that can move into Europe, and timber without EUDR that can't. And as I say, this is a supply chain issue. You need to understand where your product could end up at any point. There's a very real risk that if we don't undertake EUDR, we'll be preventing timber from accessing certain markets, affecting the whole supply chain. However, you've come to listen to two very excellent speakers. They are Maggie Fitzherbert and John Kirby. Maggie is the Senior Responsible Sourcing Manager at the Soil Association, an expert in compliance and sustainability. Maggie oversees the Soil Association's initiatives against forest risk commodities, particularly under the EU Deforestation Regulation and the current UK Timber Regulation. John is the Executive Director at PEFC UK. John's background is in forest management, chain of custody auditing, and John plays a pivotal role in adapting PEFC standards in response to new regulatory demands like EUDR. So we're going to begin with Maggie, and then we'll move on to John afterwards. So I will now hand over control of the screen to Maggie and let her begin. Over to you, Maggie.
Brilliant. Thank you, Richard. And thank you, everyone, for joining us today. I'm going to spend the next 20 minutes or so giving you a high-level overview of the EUDR, some of the technical requirements, and some recent updates, with an idea of giving you a broad understanding of how this is going to impact the UK and the UK supply chains. So can I just check that my screen is now live for everyone?
Yes, it is.
Great. Thank you very much. So to start off, who are Soil Association? For those that don't know us, we're one of the UK's leading certification bodies. We have a global footprint for our FSC and PEFC certification, which is shown on this map. We have over 28 million hectares of certified forest in 37 countries, and coming up 5,000 in custody certificates in 60 countries. So this gives us a really broad overview of timber supply chains and global forest governance, which is us well to be looking at the new deforestation regulation. I'm actually in the climate and landscape team, where we look at other things such as carbon schemes. So we do validation, verification, and training for the Woodland Carbon Code, Peatland Code, Wilder Carbon. We also are starting to look at things such as capital, biodiversity, and nature markets. For me, myself, I look after the responsible sourcing workstream, which is the existing timber regulations, new deforestation regulations, and head up a series of services, including due diligence, gap analysis, third-party verification, training, partnerships, and certification. So, to give you a bit of context to start with on the EUDR and how we've got to where we are today. And the existing timber regulations haven't succeeded in reducing overall deforestation. Deforestation is happening around the world at an alarming rate. As we know, it has severe consequences for the climate, biodiversity, and a range of negative social impacts. There's lots of reasons why existing timber regulations haven't been successful, but just to highlight two of the main ones. Firstly, deforestation isn't generally driven by timber and the timber industry. It's driven by agricultural conversion. So the EU estimates that 90% of global deforestation and degradation is driven by conversion of forest to agricultural use. Secondly, of deforestation for agriculture is legal. So it stands to reason that if you want to create a piece of legislation which is going to have a kind of global impact and going to succeed in its aims of reducing deforestation in its entirety, then it needs to include agricultural commodities and it needs to include legal deforestation. And so hence the EUDR is born. So what it is at its heart, it's a piece of legislation that requires companies to produce verifiable evidence that their products are free from deforestation and degradation, legally produced in the country of harvest, and are covered by something called a due diligence statement. Underpinning all of this is companies needing to implement a due diligence system. I won't go into detail about that. I think that probably lots of people are already familiar with that. It's the same principles of information gathering, risk assessment, and risk mitigation that underpin the existing timber regulations and is also used by many certification schemes, including PEFC. So look at deforestation and degradation specifically. I want to highlight that there's a very specific definition of what they mean in the EUDR. So in the context of EUDR, deforestation is the conversion of forest for agricultural use. So conversion of forest into other types of uses is not covered. The prohibition is specifically for conversion for agricultural use. For degradation, we've got two main categories. It's structural changes to forest, taking the form of primary forest or natural regenerating forest into plantations, or primary forest into planted forest. So to look at what is in scope from a commodity perspective, commodity simply means anything which is bought and sold. The forest risk commodity are commodities whose production and trade are driving deforestation at the producer end of the supply chain. So as well as wood, the EU has identified 6 other commodities that collectively are responsible for most of the deforestation, or whose production trends and conversion trends means that they're likely to in the near future. For us, the audience today, we are interested in wood. So to look at what commodities are in scope, the list is broadly familiar to anyone who has had any obligations under the UKTR or EUTR. So there's a couple of additions to these HS codes, to the commodity codes that are in scope, notably the addition of charcoal, seats, and printed materials, which weren't in the previous timber regulations. Also, just a point on clarification on packing cases, pallets, and also paper-based packaging material. Packaging is in scope where the packaging itself is the product that's being bought and sold. Where pallets, for example, are being used as packaging for another product, they're not in scope. So it's important to distinguish between those two as well. Look at the timeline. Here's some of the key milestones. In December 2020, the deforestation cutoff date means that any land that was covered by forest in December 2020 can't be converted into agricultural use. Any commodities grown on that land after that date are prohibited in the EU. In June last year, the EUDR was published with an 18-month implementation period for most companies. So the clock is very much ticking. The entry into force is December of this year. At the same time, we expect several other things to happen, notably the publishing of country risk benchmarking assessments, which I'll come back to in a moment, the completion of the information system, which I'll also come back to. At the same time, the EU timber regulations will be repealed. Fast forward to June next year, any remaining companies will be in scope. So the 18-month implementation period that I mentioned is applicable to all companies, apart from those that are small and micro enterprises registered at the time of the cutoff date, and also whose commodity codes are new. So it doesn't apply to companies who were already had obligations under the EU timber regulations. There'll also be a review of scope to see whether new products should be added, including biofuels. And by the end of December 2027, the EUTR will no longer be applicable to any material. So just to look at that EU timber regulation to EU deforestation regulation transition, the EUTR will continue to apply for 3 years after it's repealed for products that meet certain conditions. And the conditions are that the trees were harvested before the EUDR was published, i.e. last June, and that the wood product is placed on the market after the entry into force of December of this year. So that's with a 3-year additional timeframe for products that meet that specific definition. There's lots of similarities with the two pieces of legislation, but broadly speaking, the EUDR has a wider scope and more stringent requirements. So to highlight some of the kind of main differences, the EUDR has a wider definition of applicable legislation. It's included exports from the EU, the scope. For companies who are implementing mitigation actions, there's a requirement for an independent audit function. We have new and expanded definitions of operators and traders. It includes any deforestation which is legal in the country of harvest, and the now infamous geolocation and harvest date requirements. So between now and the end of the year, the European Commission has its work cut out for them. There's still a lot of work that needs to be done to make this implementable and workable. So the country benchmarking that I mentioned previously is where all producer countries will be categorized into high, standard, or low risk. The information system for due diligence statements still needs to be completed. I'll give a bit more detail on that shortly. We're still waiting for several competent authorities to be assigned. So this is the enforcement bodies in each member state and any associated regulatory reform that's needed to enforce it. The EU Observatory is a public-facing kind of information centre. While lots of information is on there, we believe it's still being developed to make it more usable and to fill in some of the gaps. There's more implementation guidance on its way. I think we're expecting some by the end of this month or in June, because there is many parts of the legislation where there's still outstanding questions on how it can be technically interpreted and implemented. And also we're hoping for something that is akin to a geolocation data sharing protocol. So this is something that would facilitate the sharing of geolocation data from one company to another, to prevent all companies going off and trying to do it in different ways, and then the data doesn't become compatible as it's shared throughout the supply chain. I'm going to give a bit more detail on the first two of these as we have some updates. So firstly, the country benchmarking for the national risk level. We understand that consultant has now been assigned, and so they will start on the country benchmarking assessments, looking at criteria, including forest cover, deforestation, agricultural trends in the country of production, information from NGOs, governments and other stakeholders, as well as a general assessment of the forestry governance in those countries. It's a question that I'm asked a lot, is whether I think the UK will be in the low risk category. I just want to highlight the methodology itself hasn't been published, so no one can know for sure. And until it's published, all countries are given a standard risk rating. Needless to say, based on the criteria that is within the legislation, I think that there's every chance the UK will be low risk. But in terms of what that means in practice, the customers in the EU will still need to do due diligence on the UK supply, but it will be what's called a simplified due diligence. So the information gathering requirements are the same, and that includes the geolocation requirements. So the importers in the EU will still need the precise geolocation coordinates for the UK supply, but they won't need to do the full risk assessment and risk mitigation activities. They'll only need to do the risk assessment on the risk of mixing within supply chains to verify the product is indeed from low risk. So there's some reduction in requirements, but the due diligence obligations are not waived if the UK is placed in a low risk category. So one of the things that the companies in Europe will still have to do is produce the due diligence statements. This is another thing that I'm asked questions about quite a lot, so to give you a little bit more information. What is a due diligence statement? It's the information that operators will submit into an online portal called an information system. So this is an online web form where companies will upload information about their products and will get a reference number in return, and they need that to be able to trade. The information that goes in is accessible by the enforcement agencies, the groups called the competent authorities, but not to the businesses themselves. In terms of what information actually gets submitted into it, it's the details of the company who is placing the product on the market, details about the product itself, including the scientific names of the timber that's used in all the products, the geolocation of the forest or farms from where the products come from, If the product's already been on the European market, it should already be covered by a due diligence statement reference number. So that needs to be included as well. And finally, the negligible risk conclusion, which is a result of the due diligence exercise that confirms that there is no risk of non-conformance or negligible risk of non-conformance of the product, and that it is safe to be cleared for trade. Going to look at the geolocation requirements in a little bit more detail, because this is one of the most challenging aspects for companies who are trying to conform to this regulation. The geolocation of all plots of land is mandatory information for the due diligence statement. So there are no exceptions for this, apart from material which is 100% reclaimed or recycled. The dates are also required, not for the due diligence statement themselves, but as part of the due diligence information gathering exercise. The dates of harvest are required. So this is a time range of a harvesting operation. The data itself is latitude and longitude points. If the plot of land is under 4 hectares, a single latitude longitude point is required. For anything over 4 hectares, then you need to do something called polygon mapping, which is a series of latitude and longitude points that describe the perimeter of the plot of land. For composite and mixed products, I think this is, again, one of the more challenging kind of areas to work out how to, viably manage your information systems and how to conduct traceability properly. So just to clarify that for composite and mixed products, you still need all relevant inputs to be from a known origin. The products can't be mixed at any stage of the process with commodities of an unknown origin. And this is because unknown origin is treated the same as product from deforested land. So what this means in practice is that there is no provision for a mass balance system within the EUDR. When looking at how to implement traceability and trying to link a product to a plot of land, there's 2 broad approaches that companies can take, or a combination of both. So there's physical segregation, beg your pardon, which is the most streamlined approach, but it is operationally difficult and the infrastructure isn't necessarily there in the supply chain. The alternative is to have an aggregated list of all suppliers, which is difficult to maintain and has increasing confidentiality challenges. This is known as declaration in excess. The EU published a series of FAQs back in December, which I encourage everyone to go and look at because it has some good points of clarification. One of them is on this term declaration in excess. So what it means is where an operator is including land in a declaration that didn't actually produce the commodity that they're selling you. So from the point of view of upstream companies and producers, it's often considered easier because it reduces the need for segregation. However, it means that the operator is taking the full responsibility for compliance of more land. So this increases the volume of data that moves through the system. That means in turn that there's an increased administrative burden and also more due diligence needs to be done. Evidence of negligible risk is needed for a larger area. And from a risk perspective, it's important to note that one non-compliant plot would make the whole consignment non-compliant. So even if you had 99% that was from known, traceable, compliant origins and 1% was from unknown, it would risk the whole plot being non-compliant, fines of up to 4% turnover of the company, confiscation and prohibition from the market, as well as other penalties. The next one is that I want to highlight is the information system for the due diligence statements. So there was a pilot conducted earlier in the year, which I think was finished at the end of January. It was broadly considered to be unsuccessful, where the initial model of the information system just simply wasn't fit for purpose. So they've been busy redesigning it, and here is a timeline of the next steps between now and the end of the year. So right now we're in May with the publication of the API technical specifications. So part of the outcome of the pilot was they realized they needed an API piece of software that was going to allow different databases to talk to each other and provide an option for the mass upload of geolocation data. so that it didn't have to be uploaded one GPS point at a time. So the API technical specifications have just been drafted. They've been shared with various working groups and task forces. I believe they're due for broader publication on the EU website in the coming days or weeks, but we do have copies of them and are happy to share. If anyone is desperate to get those technical specifications now, please just ask. Next month, we expect them to start doing some testing of those sessions, and then with informative videos, instructions, guidance coming out throughout the summer. Training should begin in October with an opening for registration in mid-November. The actual opening of the system for companies to start using it isn't till mid-December. So for an entry into force date of the end of December, this is obviously a very, very tight timeline. For the geolocation data, I won't go into all of this, it's very technical, but the main thing to flag is that they have confirmed that the GeoJSON file format will be the geospatial data file type that will be used by the API. They've also made some announcements with regards to the data standard of projection systems that are used, some limitations on what can be uploaded, and some other associated information that needs to be tagged alongside the geolocation data upload, such as country, producer name, and the production place name, and so on. There's a link which is in tiny writing at the bottom of this. We'll share the slides afterwards if you want to look at these EU slides directly yourself afterwards. The next one, I was considering whether or not to include this. It's quite contentious, but considering it is the question on everyone's lips, I think it'd be the elephant in the room if we were to avoid it. So will there be a delay to the implementation of the regulation? The first thing that I want to point out is that the law is already adopted. It's already in force. So any changes to dates would require a change of law. It's not just a question of not implementing the law would actually have to be changed to allow for a delay. Considering the upcoming EU elections in June, it's unlikely that those legislators are going to be drafting any delays at the moment. Acknowledge that there's a lot of industry lobbying and pushback on this. I think there's concerns around the timelines and the workability of some elements, such as the country risk benchmarking assessments and the information system, as well as other aspects of the guidance that hasn't yet been completed. The advice from us is that businesses have to assume that the date will go ahead at the end of 2024. Without an announcement to the contrary, it would be very dangerous to hedge your bets and assume that there will be a delay, considering the amount of work that many companies are going to need to do to comply. So what does the EUDR mean for UK businesses? If you're trading within Great Britain, then there's no direct legal obligations. If you have operations within the EU, then you will have due diligence requirements as either an operator or a trader. For any products destined for the EU, whether that's you selling them directly or your customer's customer, then information requests are going to start coming up the supply chain. It's very important that UK companies share the geolocation data and the harvest dates that will allow EU companies to comply with the EUDR. So a failure to cooperate within this will result in the exclusion from the EU market, because without that geolocation and other information upfront, the customers in the EU won't be able to submit information into the information system. They won't be able to get the due diligence statements, reference numbers that will allow them to trade the products. In Northern Ireland, we still don't have any official announcements. So assuming that the EUDR will be implemented and there's every likelihood of simultaneous compliance with the UK timber regulation and the EU Deforestation Regulation, unless some deal is arranged to the contrary. So that brings me to the end. That was very much a whistle-stop tour. So I hope you found that useful. Want to kind of give some general recommendation, general advice on what companies should do now, especially if you're hearing about this for the first time. So the first step is to try and understand what your exposure to this is from the point of view of the product and your place in the supply chain, and also the risks that might be associated with the origin of your product and the supply chains. Once you've done that, we recommend that you start reviewing your procedures, any existing risk management mechanisms that you have, traceability systems, have a review on your staff knowledge and capacity to try and understand what resources are going to be needed to allow you to align with the deforestation regulation. And then finally, to actually take action with an implementation plan, educate and engage your suppliers, map your supply chain, get that visibility and that traceability to forest level for all of your supply, and start putting out those information gathering requests through your supply chain. So that's it from me. If you want any kind of follow-up, please do feel free to contact me. We're also running a series of training courses. The next one, which I think there's a few spaces left on, is a few weeks on June the 5th. It's online. And we also have due diligence system auditing and certification services as well. So please do get in contact. And that is it from me. So I will now pass back to Tom, if I can find the right button on my screen. One moment.
Thanks, Maggie.
Okay, so our next speaker is John Kirby, and I'm hoping that he now has control of the internet effectively to start to share his screen.
Things are happening, so I'm encouraged.
John, have you got control?
I think I have. What do you...
Over to you then.
Can everyone see that?
Yes, we
Lovely.
can see that.
Fine. Okay. First of all, thank you to Confor for inviting us to speak today and go through the PEFC EUDR alignment project. Very similar to Maggie, I'm going to speak for about 15 minutes. So just give an overview of where we are with the alignment project and the strategy which PEFC is adopting, both at SFM level and at chain of custody level. So I'm John Kirby, I'm Executive Director of PEFC UK. Just a very brief update on where we are in terms of certification in the UK. We currently have 15 PEFC FM certificate holders. All of those certificate holders are dual certified, both FSC and PEFC. It covers an area of about 1.55 million hectares. That's about just under 50% of the UK forest area and covers about 80% of commercial conifer stock. And there's about additional 75,000 hectares is certified it's just FSC only certified. That's covered under an additional 6 certificates. Chain of custody wise, we have a total of 898 certificates. 207 of those are multi-sites, 690 are single sites, and we have 1 producer group with 168 members. So EUDR, obviously, when the legislation was brought into place, the first question that was asked within the organisation was this something that we need to get involved with? I think we quickly realised it was something that we did. So was born the PEFC EUDR alignment project. And the work's been carried out at international level with the assistance of the national governing bodies, of which PEFC UK are one. There's been 4 branches of work really. One is looking at sustainable forest management, technical developments, chain of custody technical developments, integrity development in terms of data stories, data capture, geolocation data, what the management strategies around that, and then also how we engage with the EU to make sure that we are supporting our members and keeping on top of legislation as much as possible. So starting with the sustainable forest management technical development, a task force was established in December 2023, basically with the mandate to look at the existing SFM standard 1003 2018, and look at how to bring that into alignment with the EUDR requirements. So that task force was made up of a number of representatives globally, both of EU countries and non-EU countries, and the UK, I was involved in that. We seem to have three groups in that. We have the EU countries, the non-EU countries, and I tended to be a group of 1, given our proximity to the EU. So it's been identified at quite an early stage that the UK has quite a unique role in relation to EUDR. Things that we were assigned to look at is, A, did we fully align the standard with EUDR, or did we adopt a modular approach? After some long conversations, the consensus was agreed that full alignment of the SFM standard was the best approach, or the approach we wanted to take. So the main body of work we've been looking at with the standard is looking at the forest categories, and aligning the forest categories in there with the EUDR categories, obviously, but still allowing, with the bottom-up approach that we have, allowing the countries to still use their own definitions, but make sure they are in alignment with the forest categories within the standard. Forest conversion, additional definitions for forest conversion, additional definition for forest degradation, geolocation requirements. It's always been a requirement to keep an inventory of areas that are being harvested, active forest areas. But again, it's adding that geolocation data that would allow that alignment with EUDR. The cut-off date, we had a cut-off date for conversion of December 2010 within the standard. There was much debate about whether to move that to 2020. However, as a task force that was set, given the mandate of assessing the compliance of the standard with the EUDR, given the fact that the 2010 cut-off date was in compliance, we felt there was no need to change it. So the current draft of the standard maintains the current conversion date of 2010. That isn't fully finalised yet, but that's the approach that we've taken. Also, there's a number of amendments required to Appendix 2, which covers our trees outside forest requirements. And I'm pleased to say we've agreed an inquiry draft of that standard now, and that's out for public consultation. It went out on the 13th of May. It's a 60-day consultation. If you scan the QR code, then that will take you to the webpage where you can get access and participate in the consultation. And I would encourage as many stakeholders to do that as possible. You know, the bottom approach that we had, we need engagement by the stakeholders. We need their say-so on the standards. So please do participate, and each comment that we receive is taken into consideration. So the adoption timeline for ST1003, so as I said, it's a 60-day public consultation that lasts until the 13th of July 2024. Once that is completed, the SFM working group will then consider comments from the consultation and then approve a final draft of the revised standard. That will go before the PEFC International Board for approval. Once they've approved it, is then sent out to the national governing bodies for a postal ballot. And PEFC UK would get a vote on that. And then once that final document's approved, which we're probably looking towards August time, we can then commence the adaptation of that standard. Obviously, given that we are going with a strategy of fully aligning the SFM standard, in the UK there will be implications for UCWAS, and there will be some alignment required with UCWAS. Personally, I think having an understanding of the supply chains in the UK, and that so many of the companies who are using FSC, PEFC certified material in the UK, and hence are certified to UCWAS, the majority of round in the UK into a sawmill, co-products ended up at wood manufacturers, you know, your West Frasers, Eggers, Cornerspans, who potentially want to export into the EU. EUDR is going to become apparent for many of the, for most of the supply chain in the UK. So actually, fully aligning UCWAS, in my opinion, would give it a benefit, and it would give the assurance to, you know, the sawmills, etc., that when they get the request for information from the operators who are exporting, they're going to be able to provide assurance and the information that's going to require those operators to be compliant with the EUDR. The implications on non-alignment, as Maggie said, the timescales for this are very tight. Given the fact we are the likelihood is that UCWAS won't be aligned by the implementation deadline at the end of the year. So the implication on non-alignment at the moment, the EU becomes active. So any timber from PEFC certified forests in a non-aligned national system will be treated as not fully EUDR aligned. So basically a more substantive DDS check by the operators or the traders will be required. Onto the chain of custody. Looking at the chain of custody technical development, this work was conducted by the chain of custody working group. The objective really was to have it was felt that a modular approach was appropriate. That could be, so basically certified companies have the option to achieve EUDR compliance or not, or they could stick with the existing ST2002 standard. And the idea was that it could be used at any any link in the supply chain. So if you're at link 3 in the supply chain, link 1 and 2 had not implemented the PEFC EUDR DDS, the third company was still able to implement the EUDR requirements at that stage in supply chain. So the working group have developed the PEFC EUDR DDS. And that can be implemented at product group level. So companies, certificate holders will choose which products they can implement the DDS at. So if a company has 10 product groups, they know 5 of them are going to end up in the EU, another 5 won't. They can just apply the PEFC EUDR DDS to those 5 relevant products. They would then apply to their certification body for an extension of scope to include the PEFC EUDR DDS for the specific product groups they want to include. The certification body will then conduct an audit, scope extension audit, and then amend the scope, and it would form part of their annual surveillances after that. Obviously, there'll be additional information required in terms of species, and also there'll have to be a revised suite of claims added to management systems that cover both the existing non-EUDR aligned materials and the new materials which have gone through the new PEFC EUDR DDS. So basically, there'll be prefixes of PEFC EUDR added to the existing claims. So if material is outside the scope of the PEFC EUDR DDS, it will simply go out with the current existing X% PEFC certified, 100% PEFC origin, PEFC controlled sources. If the material has gone through the DDS, the PEFC EUDR DDS, sorry, then a prefix of PEFC EUDR will be added to those claims. The key elements of the DDS. So basically, it's a collection of information for incoming raw materials and supply. So whether it's if material is delivered under a PEFC EUDR claim and there is an EU Information Centre reference number, then the only information that needs to be gathered can be on request. So all the relevant information is there. The material is already considered to be fully aligned with EUDR and simply can be passed down the supply chain. Obviously, if the information is required further on down the supply chain, then the information has to be available on request. Otherwise, additional information is required. So if materials just supply with the PEFC EUDR claim, but no reference number, then risk assessment needs to be carried out accordingly. If no PEFC EUDR claim, then a full risk assessment is required in accordance with the DDS requirements. So the risk assessment is split into 4 sections. One is assessment of the risk of deforestation and/or forest degradation by the company. So looking at evidence of how they've ascertained that. Legality, as defined in EUDR, is the material legally compliant. Risk of controversial sources, and then complexity of a mixing at supply chain. Obviously, as Maggie referred to, where's a mix of materials, each component part, the origin of each component part needs to be known, and there can be no unknown sources within the material. So that step in the risk assessment assures that process has been carried out by the company. Just in terms of the timescales for the DDS, the public consultation ended on the 7th of May 2024. The Chain of Custody Working Group met in Paris on the 9th and 10th, just before our annual Forest Forum. They addressed any comments that were raised to the consultation, of which there were about 700, I think, and prepared a final draft. The final draft was agreed and approved by the PEFC board on the 12th of May, and now we are waiting the postal ballot where we can vote to approve the standard. So we are nearly there with the EUDR DDS. Once that's approved, national governing bodies, we will need to adopt our schemes accordingly to incorporate it, and then roll out accreditation scope extensions for accreditation of the certification bodies, training of auditors, and we will host a number, I think, of information days for our certificate holders where we will present the DDS and go through a step-by-step process through the DDS. So hopefully, certificate holders who want to use this will be able to give you a clear understanding of the steps you need to follow when going through it. Obviously, the DDS is a tool to help companies achieve EUDR compliance. There's no guarantees here. Obviously, at any audit, it's a sampling process, looking at what's presented before us. It will still be the responsibility of the certificate holders to be legally compliant with the requirements of EUDR. The data task force that was established to look at PEFC's strategy of collection of data, storage of data. I think after some significant discussions, a broad consensus was reached that geolocation data, harvesting data, and other production data in respect of EUDR would be left to the actors in the supply chain. And PEFC did not feel they had a central role in this or developing a single piece of software that they would require their certificate holders to use. PEFC's strategy here is to engage with a number of technology providers and partner up with a number of tech companies who can then offer technical solutions to certificate holders if they want it. There's a number of certificate holders who may already have the software that allows them to demonstrate their EUDR compliance. So we feel, again, the bottom-up approach, allowing the companies to determine their own destiny, is the appropriate way forward here. Obviously, whilst we don't really involve that side of things, there will be a number of amendments to the PEFC database that you will see over the coming months in respect of the rollout of DDS. There will be more information fields required on the database and hopefully some simplification of the database as well. Some of the staff now that are international who have a practical knowledge of using the database have identified a number of areas that of improvement, so they're working closely on that. So hopefully there'll be a more streamlined database available in the not too distant future. In terms of engagement with the EU, obviously we're waiting for the guideline document that's going to be brought out. We understand there's going to be 11 areas contained with it. One that we're particularly interested in, and I'm sure my colleagues at FSC are, is the role of certification. Obviously, neither PEFC or FSC have green lane status in this, but we're certainly seeing, I would hope, both the schemes are as starting points for this and advantageous in terms of demonstrating compliance. So we're waiting with keen interest to see what information is in the guideline document. FAQ, the EU have a FAQ document which is updated regularly. Again, a useful document in terms of gathering information. It's something that we certainly look at. The country benchmarking system, again, something that we're keeping a keen eye on yet. And again, as Maggie inferred, I think the contract has just been assigned to this, but currently we are still acting, certainly the UK, as a standard risk country. Just in terms of the competent authorities, as of 11th of March, the ones with the ticks next to them have assigned a competent authority to monitor this. Apart from that, there's still a number of others who have not yet assigned a competent authority to monitor all the commodities that are included within the EUDR. So there's still a lot of work to do on this. That concludes the presentation that I have on this. So I will hand back to Richard, and we can go through the Q&A.
Thank you, John. Okay, two really interesting presentations there. I've got a few questions that have come through onto the chat. I won't do them in order, but I will start and we'll hopefully get them answered. So we're going to start off with, I hope this is quite a straightforward one. It says, we don't export into the EU, but we do source timber from the EU. How does this affect us? So quick question there that I'm going to put to Maggie and to John. So does EUDR affect you as a retailer in the UK if you're just importing?
I'll take that one.
Yeah.
So it will have limited impact in that case. If you're selling to the end customer, such as a retailer, then you can be fairly confident that your products aren't going to end up in the EU. So the people exporting from the EU will have to be covered by a due diligence statement. Depending on the product, that may or may not be included as part of your own due diligence for your UK timber regulations to prove that it was legal from, the supply chain perspective. But if you're not selling into the EU, it won't have an impact. Having said that, the only people who can really demonstrate clearly that it's not going to go into the EU are people who are right at the end of the supply chain, such as retailers and people who are not selling into any further kind of manufacturing or sales, trading kind of processes. So anyone who is still doing manufacturing where there's any kind of co-products being produced, then it's very hard to say for certain that there's never anything that's going to end up in the EU later.
Thank you. So we're going to go to another one, which I think is quite important. It says, what are the implications if you're harvesting cell for a new public road, i.e. not certified? Could this be considered as degradation? Yeah, there you go. Can't get that word out this morning. See if this afternoon. So, John, I think this is probably a chain of custody issue for you. Is this controlled wood and how does this fit in? But I'll let Maggie jump in as well if she needs to.
My understanding, and correct me if I'm wrong, Maggie, here would be that if it is infrastructure, then it is outside scope. Obviously, in terms of deforestation in terms of EUDR is purely agricultural use, so this wouldn't fall into that category. Provided that the forest type isn't changed. I mean, bear in mind at EUDR level, degradation is defined by a change in forest type. So provided that the forest type is still the same, then there is no issue on degradation. Obviously, the only where human interference is an issue would be in primary forest, where it specifically references void of no human interference. I doubt the very fact you're going to put a public road through a primary forest will get away with that. I might be wrong, but I couldn't see that legitimately happening in many places anyway. So I think generally it would be outside the scope of the EDR. Feel free to add on that, Maggie.
No, that's
kind of. I was going to say, John, that leads on to another question that we've got, which is, what is the definition of primary forest in a UK context? Is this ASW pause? I will say I've had a very quick look in UKFS and UKWAS just while we're online, and it doesn't mention primary forest as a definition. So I'm not quite sure where we stand with that in the UK.
Well, sorry, go on, Maggie.
No, sorry, I was going to say, I saw that question and so I checked the actual definition. The definition that would be used is the same, as I understand it, the same as what the definition in the EUDR text itself is. So by this definition, I'm not sure that there is any in the UK, and I'll post it in the chat as well, but it's primary forest means naturally regenerated forest of native tree species where there are no clearly visible indication of human activities and the ecological processes are not significantly disturbed. So those are the definitions that would be used by EU customer doing due diligence to determine whether the primary forest had been converted or structurally changed.
So that would certainly rule out the pause that was in that question. I did see that question come through.
Okay. Another question, and this links to UKTR. So it says, will EUDR compliant timber be considered by the UK government as compliant with UKTR? So are we crossing both T's at the same time with EUDR? I'll throw that question out to both John and Maggie.
I would probably defer to you on that, Maggie, to be honest. But
I think in all likelihood, yes, they are different legislation with different sets of requirements, but considering the EUDR is the wider of the two, then to be able to demonstrate compliance with the EUDR should fulfill the requirements of the timber regulation in the UK. Obviously, there would still be the requirement to demonstrate the legality and all the same kind of information gathering and reporting. So something as simple as an export declaration with a due diligence reference number on it wouldn't necessarily be sufficient. You'd still need to do the due diligence, but in all likelihood, the risk would be negligible and that should be able to be demonstrated. One of the key challenges that UK companies have with trying to do due diligence for UKTR and European imports is a lack of visibility within the supply chain and a lack of not being able to actually trace back to forest to demonstrate legal harvest, even if the country of harvest is low risk. Now that the due diligence requirements for the deforestation regulation mean that geolocation information has to be captured and moved through the supply chain, that should make it easier for companies in the UK to do their due diligence on European timber. But John, please expand on that as well.
Okay, thank you very much. Well, we've got about 5 minutes left, so I'm just going to pick up a common theme that actually I've been asked many times. It says, can the geolocation polygon, say, be the whole of Kielder Forest, and can the harvesting period be as long as, say, 5 years? So this is something that I've been asked about, the size of the polygons and whether it relates directly to the harvesting company or whether we can go wider to include whole forest, which may be managed separately. So it's about whether there's play in the system, I think would be the way to describe this. So again, I think this is a very good question for auditors out there to see how this is interpreted.
Yeah,
I'll put that question first to Maggie, and then I'll let John pick up.
Well, no, I'm not sure on the answer to that. I don't think that it has been defined. I think that there's kind of need to link back to different definitions of what is a plot of land, what is a duration of a harvesting activity. But I expect that more implementation guidance will come out that would probably say that the resolution of the information you need to provide is higher than in that example. As far as I know, it hasn't yet been specified.
Yeah, I think it's,
Okay.
you know, we don't sit here, so I certainly don't sit here and profess to know all the answers. And this time scale over which things are measured in terms of degradation, harvesting, etc., is something which is commonly asked. You know, in the UK, where we have different management plan lengths and there's different operations carried out over the span of that management plan, is a really important question, and something that we do need some clarification on. I think in terms of the area, I mean, I've heard talk of, you know, with the declaration in excess, it might be possible to do a larger plot of land that's covered under single ownership or single management, which could include an entire forest, even though there are active sites and non-active sites within that. So I think there's still a lot of answers that we need, still a lot of questions, a lot of answers that we still need about how this will look like on the ground. And certainly, like I say, we don't profess to know all the answers on this. It's something that's very much a moving feast at the present time.
Yeah, I think I'm going to try and squeeze one more question in, and then we'll aim to wrap up. It says, question says, does this mean that all forest creation sites, new planting since 2020 in the future, will not be able to be exported to the EU or certified if they were planted on old agricultural land, even if they are native? So I think this is looking at when the conversion happened, and I'm thinking that my immediate answer would be, because it's conversion to forestry, it would be within scope, as opposed to the other way around. So I'm just checking. I'm getting some heads nodding there. That's good. I like that.
Yeah. So
very quick answer there.
I think if it's agricultural land going the other way, it's being afforested, obviously it will then be assigned a forest type at that point. Could be plantation, could be planted forest, and that would be as it gets to maturity, that will be its forest type and would be eligible for input into the EU.
Okay, so we've got 2 minutes left, and it's quite a long question we've got, so I'm going to summarize it, and I think I will then probably leave it unanswered because it's a bigger question. But it talks about deforestation for conversion to habitat restoration, e.g. forest to bog restoration. This is something that we've discussed within the panel a couple of times, and we don't actually have an answer to as yet. So I think, although it's out there and it's a very important question, I think what we need to do is try and take that one away and come up with more definitive than the 1 minute that we have left on the webinar. So I have noted it. There's a few other questions in there which are very good, but we haven't had time to answer. So as I said at the start, we'll take those away and get some, like a short text answer to you, and then keep in touch. This is an ongoing, moving beast, as you will. So we do need to keep you up to date. It may be another webinar, it may be further meetings, or just text-based communication, but we will get this information out. So we're at the very end. I'm going to say thank you very much to Maggie. Thank you very much to John. It's been incredibly interesting.
Thank you.
I've worked on this for a while now, and I still picking up lots of stuff. So kudos to you guys to being on top of this. I think my final parting shot is to say that this affects everybody, and we're all in this. There's no way really to try and step out of EUDR and be part of the UK supply chain. I see it as all fully integrated. So we need to work together. And certainly for Con4 members, I'm speaking to you quite a lot. And we're meeting again on Friday to discuss how we as Con4 members can try and pull this together and do some sharing of data to make it work. So hopefully I'll see many of you there. But for now, I'm going to say thank you very much and enjoy the rest of your day. Thank you.
Thanks, everyone. Bye-bye.